May it please the court. Attorney Douglas Rand Peacock representing John and Elizabeth Hacharian. Basis of our appeal, this is obviously a foreclosure on a residential home, is that we feel we properly objected to plaintiff's lack of evidence and testimony based on evidence that they did not, regardless of whether they could authenticate it or not, didn't produce at trial or at the prior deposition, as indicated by the trial testimony. Specifically, evidence showing that that HSBC transferred the note or was actually even in possession or ownership of it at the time that Wells Fargo allegedly acquired that entity. There was testimony, but then when pressed, the witness admitted that there were other records she had reviewed but did not bring to court. And so it was her hearsay opinion testimony about these other merger documents and the supposed standing of the plaintiff at the time of filing.
The records she didn't bring to court were the boarding records. We ordered you on May 25th of this year to file in our record, the court record, those trial exhibits that you are arguing about today.
We don't have copies.
You have not done that, sir. They were admitted into evidence, and they were numbered, they were identified as exhibits, and they were admitted by the court. You have not done that, sir. Why didn't you comply with our order?
Your Honor, first of all, I was not given copies of those trial exhibits. Those are with the clerk's record at best. It's
your duty, once you're ordered by this court, to contact the clerk to have the clerk file those records with us. You are asking us to review this appeal from a disadvantage. We don't have those records. But yet you're arguing that they were not authenticated, that they were hearsay, they should never have been admitted. How can we give you a meaningful appellate review when you don't comply with our orders?
First of all, the records it's not the records that were admitted, the note, the mortgage, and the payment history. Those, I'm going to concede by this court's prior rulings on the authentication of records. As far as Wells Fargo's records, the court had the authority to bring into the record. What I'm contending are the records that were not submitted.
Which ones?
The payment history.
The merger documents were admitted into evidence. You didn't file those with this court. The only documents that Ms. Calvary testified she did not have were the documents indicating the boarding process to determine the accuracy of the numbers in the loan.
She also testified that she did not have the records showing that Wells Fargo was in possession of the note at the time of the acquisition.
Those were the screenshot records that you objected to, but the Wells Fargo attorney indicated to the court he wasn't moving to admit those.
And our position is they should have admitted those because those were the basis of her testimony. And again, to your question about, Your Honor, I did not get those records in. I assumed that they had already been presented, if the court even had them. How do I direct the clerk to submit records when I've already directed the clerk to submit the file up to the court?
What documentation do you have that you directed this particular clerk to comply with our order?
I do not have any, Your Honor.
Okay, so you just violated our order. You just disregarded it. Yet you're asking us to review this appeal and find in your favor. You can go ahead and proceed, but I'm just telling you that we're at a handicap here.
And
we're at a disadvantage.
My position, though, the appeal has not been on those documents that were submitted because the testimony acknowledged those documents did not state or did not show any ownership or holdership of the note at the time of filing.
Okay, so you don't object to the note. You don't object to the mortgage. You didn't file the merger documents. Well, you're aware of Florida statutes that when one entity merges into another entity, that succeeding entity takes the assets and has the rights and liabilities and ownership of those assets. You're aware of that law, correct? And that Ms. Calvary testified that this was an in-house loan. There was no testimony that this note and mortgage ever changed hands outside of these entities.
But her testimony was based on the review of records that she did not bring to court. She was not a personal, she was not holding that note through its entire process at Wells Fargo. much like a DMV worker doesn't know what all has happened in a person's file unless they look on the screen, and then they can only testify about what that screen shows. It would be hearsay for her to say what's happened previous to her being on the case. But those screen records could be authentically submitted to the court as evidence, and then they would, as best evidence, establish the basis of her testimony. So,
well, here's my next question then, because I read your cross-examination a couple of times. You only cross-examined her on the boarding documents and procedures. You never used her deposition to impeach her. You never asked whether World Savings Bank and World Bank or Wells Fargo owned or held the note at the inception of the lawsuit. You didn't move for an involuntary dismissal, and you didn't put on any evidence, much less call her as an adverse witness.
Your Honor, I did try to question her about what records she reviewed to even have a basis of that, and the court, on objection, blocked me from even asking what records she'd reviewed to come to the basis of her testimony. That was around page 28 or 30 of the deposition.
Plus, you're making an argument that paragraph 22 in a Fannie Mae mortgage applies in this case when this mortgage and this note doesn't have a paragraph 22.
I don't, well,
and this lender didn't even have to send them notice of a breach.
If I briefed that, I apologize.
No, you've argued that paragraph 22 applies, and it doesn't. It's nowhere in here.
Then I can see it does not apply.
Okay.
That's not one of the issues. That's not an issue I'm moving forward on, more correctly. Again, I'm sitting from the standpoint of, and as I stated, I was trying to, for even establish what records the person had reviewed. They clearly indicated there were other records they'd reviewed, but the court would not let me go forward on those questions. The plaintiff admitted there were other documents about these, establishing that their holdership of the note, that they screenshots she had reviewed screens, which had not been produced. Also, on my other point, which is the business records themselves, the witness admitted that they did not have the prior servicer's records. They simply had a lump sum.
But you didn't object to the testimony that there was a breach, nor did you object to the amount owed of $301,000 and some change. You didn't object to that when she testified to it.
I objected to the basis of the business records, how she got.
You objected to the payment records because they didn't go back past 2008.
Yes, Your Honor. And I objected to the whole basis of the testimony because it was based on the assumption that those records were correct. And if she had produced those records and said, here are the records, then she could have complied with this court's prior rulings that these are the prior records that we rely upon. Instead, they have, here's a number that we've generated. We're not going to show you the records, and for the record, they never showed us the records, and that was part of my objection. So I have no basis for, the court said, I'm going to accept those records as they are. I'm not going to let you go further. And the witness was allowed to testify in the assumption of effectively summary evidence of how much was owed or what the state of the loan was prior to the servicing taking hands.
And those payment records that you objected to were admitted into evidence, correct?
Yes, the ones that went back.
Those payment records were also the subject of our order that we ordered you to file with the clerk to send to us, which you didn't do. So how can we review that?
I mean, all I could say, Your Honor, is I could go back today and ask the clerk to forward them over.
It's a little late.
I understand that, Your Honor. But it's still, the testimony establishes that the deficiency in those records. The witness admitted to the deficiency in those records. So from that standpoint, I mean, there's not, even if we were to have the records, you would see the same thing that was testified to. There's no payment history prior to 2008.
Is that required in a mortgage foreclosure? They had records a year before your client breached. Your client's been in the house since 2009. They had records prior to the breach that showed that they were servicing the loan and making payments. And then they breach in 2009, and they have records all the way up to the present.
They'd still
What else is required?
Admissible evidence as to the total amount due and owing.
Well, you didn't object to that amount when she testified to it.
I did object to the basis of all of her testimony based on the lack of evidence to support it, including, and the basis was based on, the totality of her testimony depended on, in many parts, other records which were not presented. Both these other prior payment histories, which, again, by her own statement, of the boarding process they should have had. Moreover, the records that she admitted, there were other screens she reviewed establishing that they held the note or owned the note at the time of the merger. The merger just showed that two companies merged. I understand that the court's, I've handicapped the court by failing to comply with the order. However, regardless, she admitted in testimony that she looked at other evidence to establish that they actually held them at the time, not those merger documents. So for her to testify that, she has to first admit those other documents. And when the court, when I was trying to lay the foundation, either to challenge, the court wouldn't let me even inquire as to what other documents she'd reviewed. So there's an issue there where I was trying to object, I was trying to lay the foundation, trying to, at the very least, establish what the basis of the person's testimony was.
Well, point me in the record where the court cut you off and didn't allow you to ask her what she reviewed. I just don't see it. Just help me out here.
It was page 30 of it, midway through. I'm trying to establish that we haven't seen any of the procedures. Okay, this is in the procedures.
Those are the boarding records.
Yes, right.
Okay.
But as part of that, I was also asking, see, it was the analogy I made, you know, just because they say they bought apples, did they buy this specific apple?
That's the argument you made to the court. You never one time asked her if Wells Fargo owned this note or held this note at the time they filed a lawsuit. It's not in here.
Question on page 11. What documents did you review that actually say that this note was in possession of Wells Fargo, in the possession of Wachovia at the time of the merger?
That's the deposition, sir. That's not in the trial record. You didn't file the deposition. You didn't use it for impeachment.
No, this is the, Your Honor, this is the
I'm on page 11.
the voir dire. Page 11 of the trial transcript. I'd asked, what documents did you review or that actually say that the note was in possession of Wells Fargo or possession of Wachovia at the time of the merger? Okay, well, answer. What I would have reviewed was our table of contents and one of our systems, our loan imaging viewer. So right there, she admitted there was other documents.
Sir, that's not on page 11 of the trial transcript. I know you asked her that in the deposition that you filed a week after trial.
Your Honor, maybe it's 11, maybe it's 10.
Okay.
Page 13, I'm sorry, page 13. Thank you, Counselor.
The court did not limit that inquiry. The court allowed you to ask that question.
But it did establish that her testimony was based, and I went further to ask the testimony to be stricken.
Okay.
So, all of her
testimony. On what basis?
Her testimony was based on these other screens which were not produced.
Were they admitting them into evidence?
I'm sorry, Your Honor?
Did Wells Fargo admit the screenshot into evidence?
No, they did not.
Okay. How are you prejudiced then?
They have to admit them before she can testify that they actually held on to the note or the note was in the possession of Wachovia or Wells Fargo at the time of the merger. Otherwise, it's her opinion about what those records represent. Best evidence still requires that those screenshots be produced. All they may pursue is copies in our possession, or we're the servicer. of a note that's not endorsed in blank. We don't know what those records actually said. We just have her opinion about screenshots that she produced, did not seek to admit. The basis of the record, to have testimony, Your Honor, best evidence requires that it be the documents themselves rather than the person's hearsay opinion about what those documents represent. She didn't testify, nor could she have, that she was actually the person in charge of holding that loan from Wachovia to the present.
Does she have to be?
I
As
think
long
if
as she has knowledge of the process, she doesn't have to be the person that does that, does she?
Then she has to produce the documents which she reviewed, like anybody else, which are the basis of her testimony before her testimony can be admitted. And for that matter, evidence of standing is necessary to establish this case.
Okay.
And recent cases have gone to establish that a bank does have to show more than just possession of the note at time of trial. They actually have to show their standing at the time of inception, which would include showing ownership and or holdership or whatever theory they're going under at the time of filing. She could not testify to either because the screens, well, she could have testified had she brought and admitted those records.
Did you allege standing as an affirmative defense?
Yes, Your Honor, I did.
Did you want to reserve some time for rebuttal?
I would like to reserve some, yes, Your
You
Honor.
have about 4 minutes.
I'll reserve that time then.
Okay.
May it please the Court, Michael Winston from Carlton Fields on behalf of Wells Fargo. As the courts recognize, there's a fundamental problem with the appellant's position here, and that's that the appellant did not submit the underlying records that were admitted at trial into evidence. And as a result of that, the lead argument that the appellants have made is that there's a lack of competent evidence to support the judgment. Simply can't be made. It hasn't been preserved. It's not properly before the court. I did want to address two of the arguments that the appellants have made. The first is the issue of standing. Nowhere in the record is there an affirmative defense of standing showing. In fact, I looked through the record. I don't even see that the answer is in the record. But be that as it may, to the extent it's not already waived, it's a simple matter of contract law, as Judge Sleet identified. This loan was originated by World Savings Bank. Records were admitted into evidence, and there was testimony without objection that World Savings Bank merged with Wells Fargo. The witness testified that this was an in-house loan, and as a result of that merger, Wells Fargo steps into the shoes of World Savings Bank and can enforce the note. There's no endorsement showing on this note. There's no testimony. There's no evidence that the note was ever transferred anywhere. So as a matter of simple contract law, World Savings, as the named party on the note, can enforce it. Once the merger occurs, Wells Fargo, as effectively now the named party on the note and the only party showing on the note, can enforce it. That's under Florida contract law, common law. That's also under Florida statutory law. That's also under the National Bank Act, Section 215A, which we cited in our brief. All of the evidence that was before the trial court showed that Wells Fargo stepped into the shoes of World Savings Bank, and there was no evidence to the contrary showing that World Savings Bank would have the inability to enforce this. To hold otherwise, you would be required to hold that the named party on a contract can't enforce it unless they present affirmative proof that they didn't transfer their interest away. And there's no requirement under Florida law for that. The only other argument, and I was a little bit confused about it, was an argument about what the witness was testifying to about the boarding process. And actually, let me back up another step and say regarding possession of the note. We submitted a supplemental authority, and it's really just an accumulation of other cases. The Nova Star case out of the 4th District, which makes clear that possession is not the only way that you show standing. You can show it through ownership, assignment, even if you're not in possession. The only other issue is this argument, which I think Judge Sleet identified as also being problematic, is regarding what documents were produced or not produced at deposition. The deposition wasn't admitted into evidence. It wasn't used to cross-examine the witness. Effectively, what the appellants seem to be wanting this court to do is to, at an appellate level, make determinations that the trial court should be making regarding admissibility of evidence and weighing evidence and whether evidence should be excluded because it was inconsistent with deposition testimony. That wasn't made in the lower court and at trial, and it shouldn't be made on appeal for the first time. Unless the court has any other questions, I did also want to point out that we submitted a supplemental authority, a very recent case from the 4th District that deals with business records exceptions, and it is right on point with the situation that we have here with taking prior records. And here we don't even have a prior servicer. We have Wells Fargo merging with another company, so it's not as if there's a separate company out there. But the recent case that we submitted goes through and synthesizes all the various business record exceptions that have dealt with prior servicers and admissibility of records. And we think that that case is on all fours with the case that we have here. We have a witness who testified that the records were boarded into Wells Fargo's system, that they were verified for accuracy. She testified based on her experience and training that this happens on every loan. That's the same as the 4th District case. We also have a situation here where there's no payment defense. There's no claim that there were unapplied payments. And we also have testimony that Wells Fargo sent a letter to the borrowers with an 800 number inquiring any dispute about the validity of the payment numbers that they were showing now, and that the borrowers never responded by saying, no, we think your numbers are inaccurate. Unless the court has any other questions.
No, thank you.
I'm just going to synthesize my final statement down to the biggest issue I have is that the witness's testimony was by her own statements based on documents not presented first. And I think Florida law still requires that a person do more than simply testify that they read something somewhere, and that's why they think it happened. The courts have and this court has given an easy path by which banks could have admitted that document they knew about. Regardless of I'm not even talking about the deposition. I'm talking about simply at trial. If you know your witness is going to testify that we held the note at this time, they need to have that documented. That's what the person reviewed. We objected to it. We objected to the testimony based on that, and therefore I think the court erred in allowing this, not striking the testimony or finding that there was adequate evidence to show standing at the time of the filing of the case. Thank you.
Thank you. Thank you both.